The hearing room in Congress felt like a pressure chamber on the verge of exploding. Governor Greg Abbott sat at the witness table with the calm assurance of someone who had maneuvered through Texas politics for years, convinced he had encountered every conceivable situation. His wheelchair was positioned intentionally in the middle, with cameras recording his every gesture. He leaned into the microphone with the easy familiarity of a public official who had given testimony before Congress more often than most people could remember. Today, his goal was to advocate for his latest legislative initiative, the Community Protection Act, which he had pitched to Texans as the solution to their increasing worries about safety. His initial statements were smooth and refined, packed with the usual law and order messages that frequently struck a chord with his base. "We're just providing law enforcement with the resources they require to protect our neighborhoods," he declared, his tone blending typical political command with Texas swagger. A couple of seats away, Representative Jasmine Crockett had been paying close attention, like an experienced lawyer spotting every flaw in the opposition's case. At 42, the congresswoman from Dallas had built her standing by refusing to allow political rhetoric to pass without scrutiny and by preparing meticulously. As other members of the committee nodded courteously during Abbott's comments, checking their phones or whispering to assistants, Crockett stayed completely motionless. Her pen glided across her notebook with intent, not merely noting thoughts, but building an argument. In the last 72 hours, she had followed her routine for big hearings, poring over every clause of the proposed legislation, talking to experts in civil liberties, measuring it against constitutional benchmarks, and gathering practical instances of how comparable policies had functioned in other states. Governor Abbott had just wrapped up depicting a Texas dealing with escalating crime, strained police departments, and anxious communities. His remedy appeared simple: expand police powers, establish fresh types of banned actions, and supply prosecutors with extra instruments. At first glance, it came across as sensible, wrapped in wording so direct that resisting it seemed illogical. But Crockett had delved deeper. She had scrutinized the phrasing hidden in sections 7 through 12, clauses so ambiguous they might label a critical post on social media as illegal behavior, transform a nonviolent protest into a serious crime, and permit police to disband assemblies they viewed as possibly troublesome before they started. The committee chair checked the agenda and declared the moment everyone had awaited. The chair recognizes Representative Crockett from Texas for 5 minutes of questioning. Right away, the mood changed. Reporters in the audience sat up straighter. Camera teams refined their angles, and aides along the rear wall halted their chats. Those who knew Crockett's assent were aware that her 5 minutes seldom stuck to just 5, and it nearly always played out differently than the witness expected. Before diving into what followed, be sure to press the subscribe button and drop a comment about where you're tuning in from. You're going to witness a vivid demonstration of dismantling a political debate piece by piece, and you won't want to skip any of it. Maintaining calm poise, Crockett adjusted her microphone, locking eyes with Abbott before uttering her opening word. "Thank you, Mr. Chairman," she started, her voice steady and level. "Governor Abbott, I value your presence before this committee to talk about your Community Protection Act. Before we dive into the details, I want to confirm I grasp your primary assertion. You're claiming this bill is essential for keeping Texans secure. Is that accurate?" Abbott nodded, appearing certain of his stance. "That's accurate, Congresswoman. Public safety ranks as my top concern, and this law equips law enforcement with the powers and resources they need to defend our communities." Crockett nodded as if evaluating his response. "And in your testimony, you've emphasized that this focuses on cutting crime, shielding families, and backing police officers. All goals, I think everyone present concurs, are vital, correct?" Abbott's smile broadened. "I'm pleased we can find agreement, Representative." It was an entry point Crockett had invited. "Starting from shared ground is always helpful," she responded. Her manner remained polite, but with a clear adjustment that drew heightened focus from those in the room. "So, let's explore what this bill truly accomplishes. Governor, not the version from press releases or the scripted lines, but the real text you're urging Congress to endorse and finance." She raised a hefty copy of the bill, flagged with colored markers and notes in her handwriting. "Section 7 of your Community Protection Act establishes a fresh crime termed organized disruption. Can you clarify for this committee what counts as organized disruption by your standards?" Abbott adjusted a bit, keeping his composed demeanor. That section deals with cases where groups deliberately upset public order, obstruct streets, or interfere with legitimate commerce. It's fundamental public safety strategy. Crockett flipped to a marked page. Let me recite the precise language, Governor, since the public ought to hear the particulars. She read it out. Organized disruption shall be defined as any assembly of 3 or more individuals that causes or holds the potential to cause interference with regular activities, traffic movement, business functions, or public services. She glanced up. Under this wording, couldn't college students protesting tuition hikes on a public walkway be accused of organized disruption? Could parents lingering outside a school board session to voice issues be detained? Could employees striking for better pay be charged? Abbott's smile grew tauter. Those scenarios are speculative. They're not speculative whatsoever, Governor, Crockett replied calmly. These are everyday protected First Amendment actions occurring daily in Texas and across the country, and your bill categorizes them as illegal acts. Murmurs filled the space. Several members began leafing through their own bill copies. Abbott attempted to steer the discussion. Congresswoman, I think you're misconstruing the purpose. I'm not construing anything, Crockett stated, her tone stronger. I'm citing your document, and I'm not done. She moved to the following marker. Section 9 permits law enforcement to break up any assembly they think carries disruptive potential prior to any actual disruption. That's prior restraint. Governor, for decades, the Supreme Court has made it plain that government can't curb speech based on what it anticipates might occur. Abbott leaned forward. Representative, with respect, public safety occasionally demands, public safety does not supersede the Constitution, Crockett interjected right away. And that's precisely what this bill seeks to do. She pressed on before Abbott could respond. Section 11 imposes criminal sanctions for employing social media or digital communication to arrange activities that could result in disruption. She then gazed directly at the camera. Governor, do you comprehend what that implies? You've rendered it illegal for citizens to utilize Facebook, Twitter, or even texts to plan a protest. You've converted the fundamental instruments of democratic involvement into conduct viewed as criminal. Abbott's expression started revealing annoyance. Those clauses incorporate protections. Where? Crockett inquired. Point out the protections, Governor. I've gone through this bill 3 times from start to finish, and I've had constitutional law experts from the University of Texas, SMU, and Baylor review it. Do you know their consensus? They said the bill couldn't withstand its initial constitutional test. They said it outright erodes the First Amendment, and they said it's crafted to accomplish exactly what it would, stifle dissent and punish protests. The murmurs in the room intensified. Abbott changed approaches, his voice turning mildly patronizing. Representative Crockett, I realize that as a relative newcomer to Congress, these matters might appear. Governor Abbott, Crockett interrupted, her voice steady and exact. I'm halting you right there. Prior to entering Congress, I worked 15 years as a civil rights lawyer. I defended protesters jailed for using their First Amendment rights. I've contested unconstitutional statutes like this in state and federal courts. So, don't imply that I lack comprehension of what I'm examining. The room grew quiet. Abbott's prior assurance diminished, and even certain Republican committee members seemed uncomfortable with the interaction. Crockett proceeded, aware she had altered the momentum. Let's examine the real results of laws similar to yours, Governor. We don't require guesswork. We possess solid examples. She raised another bundle of papers. Following the 2020 George Floyd protests, no fewer than 17 states enacted comparable laws. Here's what transpired. In Oklahoma, senior activists got arrested for assembling outside the state capitol to oppose education reductions. In Florida, environmental supporters faced felony charges for setting up a beach cleanup that featured climate awareness banners. In Iowa, advocates for disability rights were prosecuted for obstructing entry to a senator's office amid a healthcare demonstration. With every instance, Abbott became more rigid. Crockett wasn't presenting hypotheses. She was illustrating exactly how analogous laws have been used to mute ordinary individuals. But here's my larger worry, she stated, her tone intensifying. Your bill extends beyond those state statutes. Section 12 establishes civil responsibility for anyone offering material aid to activities resulting in arrests under this act. Do you grasp what that entails? If a church supplies water to protesters on a scorching day, they might be sued. If a nearby business allows activists to use their facilities, they could incur fines. If a lawyer gives complimentary legal advice to someone detained under this law, they could be accountable. She leaned in a bit. Governor, you're not merely criminalizing protests. You're attempting to stop communities from aiding each other in practicing constitutional rights. That's not public safety. That's authoritarianism. The statement hung in the air. Journalists typed furiously. Cameras clicked. Abbott's look changed from assured to aggravated. Representative Crockett, he responded stiffly. That depiction is completely unjust. Is it? She questioned. Let me pose it to you straight. Under your Community Protection Act, could the civil rights marchers who journeyed from Selma to Montgomery in 1965 have faced arrest? Abbott hesitated, obviously mindful of the ramifications. The historical setting is entirely distinct. Answer the question. Could they have been arrested under your bill? Yes or no? The details would hinge on, yes or no, Governor. Crockett urged. Would the Selma marchers, individuals seeking voting rights, be deemed criminals under your law? Abbott's jaw clenched. The purpose of that march and the aim of this bill are entirely, that's not my question, Crockett countered. Under Section 7, there were over 3 people interrupting traffic flow. Under Section 9, they could have been scattered for possible disruption. Under Section 12, the churches and families supporting them could have been sanctioned. Your bill would have rendered the civil rights movement unlawful. Governor, the room burst into chaos. Some Republicans demanded order. Democrats cheered. Reporters yelled inquiries. Abbott remained at the witness table, his prepared remarks unraveling. Crockett went on, raising her pocket constitution, a habit she frequently employed in intense hearings. Governor Abbott, she declared, her voice resolute, the First Amendment doesn't state Congress shall make no law limiting free speech unless an authority figure considers that speech disruptive. It doesn't state the right to assemble stays protected unless a governor rules differently. It states these rights shall not be infringed. Period. She gestured to the bill. This law infringes those rights time and again. And you requested this committee to regard it as straightforward public safety, presuming nobody would scrutinize it thoroughly. But I examined it. My staff examined it. Legal experts examined it. And we all arrived at the identical judgment. This bill is hazardous, unconstitutional, and at odds with a free society. Abbott tried to reclaim the narrative. Representative, if you permit me to clarify the background. The background, Crockett answered, is that you're seeking federal funds for a state law that turns constitutional rights into crimes, and this committee would neglect its duty if it provided you even $1 for that goal. She addressed the chairman. Mr. Chairman, I propose we promptly shelve any deliberation of federal backing for Texas's Community Protection Act until a full constitutional assessment by the Congressional Research Service. Multiple Democrats swiftly endorsed. The chairman, caught off guard, summoned order and indicated the proposal would be evaluated as other members continued their inquiries. The effect was evident. Abbott's effort to portray the bill as sensible public safety had been taken apart. Segments of Crockett's interrogation circulated on social media. In under an hour, Crockett dismantles Abbott trended across the country. Legal authorities weighed in. Former Attorney General Eric Holder posted, Representative Crockett's interrogation of Governor Abbott served as an exemplar of constitutional insight and proficient supervision. The ACLU released a declaration commending her breakdown. Even conservative legal analysts who had originally backed the bill started to withdraw. One informed Fox News he harbored worries about constitutional problems he hadn't fully weighed. By evening, Abbott's office put out a protective announcement asserting Crockett misread the bill, but the political harm was inflicted. Texas lawmakers who had intended to approve the bill hesitated. National Republicans eyeing similar measures retreated. 3 days on, the Congressional Research Service issued an initial report identifying several sections of the bill as posing major First Amendment issues. 2 weeks later, under mounting strain, Abbott announced he was reassessing portions of the legislation, broadly interpreted as recognition that the bill was no longer feasible. For Jasmine Crockett, the hearing marked another pivotal point in her national prominence. But during a local town hall, she maintained focus in her comments. "I didn't aim at Governor Abbott on a personal level," she stated. "I contested a bill that would have converted constitutional rights into illegal actions. My role is to scrutinize legislation meticulously, comprehend its practical effects, and voice concerns when something endangers core freedoms." A grandmother in the crowd, who had been arrested in a nonviolent protest regarding pollution close to her grandchildren's school, rose with tears streaming. "Thank you for scrutinizing those bills so diligently," she expressed. "Thank you for grasping what they signify for folks like me." The instance, captured on a phone and shared extensively, illustrated why Crockett's questioning struck home. She wasn't chasing spotlight or aiming to produce a viral moment. She was safeguarding the rights that enable Americans to express themselves, gather, and demand accountability from their leaders. If this dissection of how Representative Jasmine Crockett confronted Governor Abbott's unconstitutional bill proved useful, tap the like button and subscribe for additional insightful examinations of crucial moments in American politics. Leave a comment below with the topics you'd want Crockett to tackle next, and distribute this video to anyone worried about safeguarding constitutional rights. Your backing assists us in keeping up coverage of vital narratives on protecting democracy.